Artificial intelligence, also known as AI, has become nearly ubiquitous in everyday life. Given AI's widespread use across industries, it is no surprise that the United States Patent and Trademark Office, USPTO, has taken a keen interest in AI, issuing guidance on how AI should be treated and used by USPTO personnel and patent practitioners alike. In Baker Hostetler's third annual IP Perspectives Thought Leadership piece, BHIP, the Intellectual Property Practice Group highlights myriad IP-related topics that are at the forefront of industry developments and current challenges and trends. I'm Leanne Lee, and you're listening to Baker Hosts. On today's episode, we discuss AI meets USPTO, the United States Patent and Trademark Office's evolution in the digital era. To provide us with insight into this topic, we have ARabinowitz, a partner in the Intellectual Property Group at Baker Hostetler and co-leader of the IP technology team. Welcome to the show, Aaron.
Thank you very much for having me.
So, to start us off, your article mentions that recent USPTO developments may signal a move away from treating AI as categorically ineligible for patents. So, what prompted the office to update its guidance in August 2025?
In a nutshell, artificial intelligence claims were too often landing in the abstract idea bucket, especially under the mental process rubric. And this was happening even when the claim steps simply could not be done in a human mind. So the August 2025 guidance reminded examiners that if a claim involves artificial intelligence in a way that isn't practically performable mentally, that claim should not be boxed in as a mental process. And the guidance also reiterates that even if a claim recites a judicial exception, examiners still have to ask whether the invention integrates that exception into a practical technological application.
Okay, so how does that guidance actually change day-to-day examination for AI inventions?
Yeah, that's a good question. The guidance changes things day to day in a couple ways. So first of all, examiners are being nudged to look for concrete technological improvements, say to things like computer functionality or improvement in some other technical field. If the claim shows that kind of improvement, then the claim can be eligible even if the claim also includes an abstract idea. So the focus is now on whether the claim meaningfully integrates the exception into a practical application, not just on labeling the claim as an abstract idea and stopping there.
So, in your article, you mentioned the decision in Ex parte Desjardins, which is an appeal review panel decision from September 2025. What's the significance of that decision?
In that decision, Director Squires vacated a PTAB rejection of claims that related to training machine learning models on multiple tasks and letting a single model handle each task while reducing the storage needs and system complexity. And Director Squires recognized that even if an abstract idea were present, the claim still recited an improvement to the model's operation. And what's especially important here is that Director Squires warned against equating machine learning with an unpatentable algorithm, and also warned against waving away or otherwise disregarding remaining claim elements as being just generic computer components without also providing an adequate explanation for setting those elements aside.
Your piece also mentions that the USPTO isn't just regulating AI, as the USPTO is also using AI. So, what tools did they roll out?
Sure. There's a couple tools that the USPTO rolled out. The first of those is the Automated Search Pilot Program, which launched in October 2025. And that program uses artificial intelligence to perform prior art searches and then issues an automated search results notice, sometimes known as an ASRN, that includes up to 10 relevant references. And that search results notice is issued before substantive examination begins, which gives a patent applicant a chance to adjust their claims or even give some thought to whether the claims might be patentable ever down the road in prosecution. The second of these big tools is something called Design Vision. And that's a tool that allows examiners to run image-based searches across numerous design databases.
And you also provided some guidance for practitioners who use AI tools. So, what exactly are the guardrails here?
Sure. There's a couple guardrails to keep in mind. So first of all, a human has to review and sign all filings. Second of all, the duty of candor and the duty of disclosure still apply absolutely, especially if artificial intelligence tools are used to help generate specifications or populate IDS submissions, as some examples. So even though artificial intelligence tools can assist, the ultimate responsibility still remains with the practitioner.
In all, it sounds like the USPTO's view of AI has evolved pretty quickly. So what's the bottom line here?
The bottom line here is that the USPTO is signaling a real shift and a change in the way that artificial intelligence is viewed. So first of all, artificial intelligence is now clearly a subject of protection. It's something that's patent subject matter eligible, especially when it delivers technological improvements, and the USPTO is making sure that everybody understands that. Second of all, USPTO is signaling that artificial intelligence is now being used as a tool that will modernize examination and hopefully make things more efficient. So even though the long-term effects of artificial intelligence will take some time to unfold, it seems pretty clear that artificial intelligence use is here to stay.
This has been a great discussion, Aaron. Thanks for your time.
It's my pleasure. I appreciate the invitation.
If you have any questions for Aaron, his contact information is in the show notes. And as always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with the lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.